to join us today. Professor Josh Blackman is an associate professor of law at the South Texas College of Law in Houston. He specializes in constitutional law in the United States Supreme Court and the intersection of law and technology. He is the author of the critically acclaimed Unprecedented, the Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. Professor Blackman was selected by Forbes magazine for the 30 under 30 in law and policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He is an adjunct scholar at the Cato Institute. Professor Blackman is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, which we always ask you to talk about.
Should all play.
The internet's premier Supreme Court fantasy league, and blogs at joshblackman.com. He leads the cutting edge of legal analytics as director of judicial research at Lex Predict. Professor Blackman is an author of 36 law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. So thank you so much for joining us, Professor.
Thank you. It's my pleasure, and I'm sorry I'm not here in person with you all.
Yeah. And Professor Geddix, of course, is a great professor at our university. I'm enrolled in his class, and I think he has promised me extra credit for inviting him today. Professor Geddix has held the Guy Anderson Chair at the law school since 2005. He is widely published on law and religion, constitutional law, constitutional interpretation, including 3 books: Freedom of Religion and Secular Government, The Rhetoric of Church and State, a critical analysis of religion clause jurisprudence, and Choosing the Dream, the Future of Religion in American Public Life. Professor Geddix's current research is focused on legal issues posed by religious accommodation statutes after the U.S. Supreme Court's decision in Burwell versus Hawley, including substantial burdens, how courts may, and why they must, judge burdens on religion under RFRA, as well as many others. He's published in the Harvard Journal of Law and Gender Rights and Liberties and Law Review as well, and with Oxford University Press. Professor Geddix was the principal author and counsel of record of a Supreme Court amicus brief filed for himself and 20 other church-state scholars in Hobby Lobby, which argued that for-profit employer exceptions from the contraception mandate violate the Establishment Clause, and published a widely read op-ed in Washington Post on the same subject. Other recent publications include Cross, Crucifix Culture, an approach to constitutional meaning of religious symbols, Corporation of the Establishment Clause against the States, and Narrative Pluralism and Doctrinal Incoherence in Hosanna's Report. Professor Geddix grew up in New Jersey and Southern California. Following graduation from law school and a clerkship on the Ninth Circuit, he practiced corporation securities law in Phoenix, Arizona, until he entered teaching. Professor Geddix joined the BYU law faculty in 1990 after 4 years at Mercer University in Macon, Georgia, and a year at the University of Denver. Thank you so much to both of these very accomplished speakers. I look forward to hearing from you, and we will start by hearing from Professor Blackman.
James, thank you so much. I usually visit BYU at least twice a year, it seems, the last couple of years, and I always enjoy my trips to Provo. Unfortunately, this year, we have to do Zoom. I see a couple of you wearing masks in the crowd. Thank you for keeping us all safe. And Professor Geddix, I appreciate that you took time out of your busy day to join us. The topic today is a timely one. The topic is the future of the conservative legal movement. And I think this is a movement that is somewhat in flux. And things that may have been settled a couple of years ago may not be so settled right now. Let's begin what I mean. What do I mean when I say the conservative legal movement? I think at least in its modern form, this movement traces the 1980s. You had several factors that sort of confluenced at the same point. You had the election of President Reagan. You had the appointment of several new conservative judges to the lower courts and the Supreme Court. And then you had the founding of the Federalist Society by a couple of law students from Chicago and Yale. I think these 3 confluences helped build an institutional growth that became the conservative legal movement. And I think there were several legs of this stool. On the one hand, you had social conservatives who favored traditional values. You also had what might be called business conservatives who liked limited government because it meant less regulation. And then you also had libertarians, where I generally find myself, who weren't so keen on the social movement, but they appreciated the role of limited federal government. And all these movements coalesced around sort of a nexus, which was a limited federal power, which preserves more autonomy for states to make their decisions. I think the movement came first, and the jurisprudence came second. The notion of originalism had been floating around for forever. Hugo Black would be an originalist. Robert Bork would call himself an originalist. So this idea had been around for some time. But I think originalism morphed, if you will, from this doctrine of restraint that just a way to tell judges stop, defer to the democratic branches. And it morphed into something more substantive, maybe called affirmative, that there are reasons why originalism tells government that they're wrong, that they can't enact certain types of laws. And I think the locus of this movement for originalism is, no surprise, Justice Scalia, who I often call our patron saint of originalism. Can I say that in Provo? Am I allowed? I think I'm okay. Maybe at Notre Dame I'll be in trouble. But I think he's our patron saint of originalism because he evangelized this topic in a way that only he could. He brought it to the masses. He explained it. Now, Scalia was far from a principled originalist. I will criticize him forever on a number of cases, but he brought this notion to the mainstream. He had decisions like Heller, which said that the Second Amendment protects the right to bear arms. He had decisions like Crawford involving the Confrontation Clause, where there were restraints on the criminal process because of the original meaning of the Constitution. In other cases, he wasn't so originalist. Free speech, for example, he never grounded his jurisprudence in any sort of originalist norm. It was sort of just, whatever. It's settled law by the Warren Court. That brings us till 2016. And I think up until that point, the conservative movement was more or less moving on a positive, unified trajectory. The Supreme Court had 5 nominal conservatives. You had the Chief Justice, John Roberts. You had Justice Kennedy, Justice Scalia, Justice Thomas, and Justice Alito. In any given case, Justice Kennedy could flip left or right. Chief Justice Roberts proved in the Obamacare case that he can sometimes find a restraint, a way out of a case through restraint. And even Justice Thomas was unpredictable in some obscure cases. But for the most part, I think the movement was unified. But then in February of 2016, something significant happened. Justice Scalia died very suddenly. He was on a hunting trip out in West Texas. And he passed away. At the time, President Obama was in office, as we all know. On the day that Justice Scalia died, there was a presidential debate scheduled in, I think it was in South Carolina. And questions were asked about who would you pick. Now, Ted Cruz and others sort of hemmed and hawed. They didn't want to give a name. But Donald Trump made a significant move. He said, here's some names. He said Bill Pryor, who was a judge in Alabama on the 11th Circuit. And he said Dianne Sykes, who was a judge in Milwaukee on the 7th Circuit. That was a significant move. At the time, conservatives were uneasy about Trump. They didn't trust him. But I think Trump recognized implicitly that he could bring on the conservative movement by commitment to judges. A couple months later, he released a list of judges, a list of 11 people that he would put on the Supreme Court. And he promised to pick from that list. Now, there were a couple names missing from that list. One name missing was Neil Gorsuch. Another name missing was Brett Kavanaugh, which is why I don't put much stock in these lists. A couple months later, in September, Trump put out another list with 10 more names. The name Gorsuch was added. The name Kavanaugh still was off the list magically. Trump won the election in November. And if you look at various polling data, one of the most significant motivators for people to vote for Trump was the courts, right? That was something that people really latched onto. They really understood that that was something important. They would not let Merrick Garland or someone else fill that seat. They wanted a Republican-appointed judge fill the Scalia seat. So Trump was elected, sworn into office in January of 17, and I think that month or the next month, he nominated Neil Gorsuch to the Supreme Court. And in hindsight, Gorsuch's hearing was fairly non-controversial. I mean, they threw some stuff at him, but nothing really stuck. He was a bit of a choir boy compared to the Kavanaugh nomination, I suppose. By the way, do you know Kavanaugh and Gorsuch went to the same high school? They were about a year apart. It was at a Maryland prep school. There were no allegations against Gorsuch of drinking and other stuff in high school. Anyway, I'll just leave that there. It's a perfect topic for BYU, right? So Gorsuch is nominated in early 2017, and then rumblings form that Justice Kennedy may be on the way out. So what does Trump do? He releases another list, list 3.0. He adds 5 names, 4 of them didn't matter. The only name that mattered was Brett Kavanaugh, which was my signal that, okay, Kavanaugh's the nom. All these fighting about poor Tom Hardiman. Tom Hardiman's a judge in the Third Circuit. He's like the Susan Lucci of the Supreme Court. He keeps being the runner-up, but never picked. Always a bridesmaid, never the bride, I guess. But he was in the running. Judge Amy Coney Barrett up in Indiana was in the running, and maybe a couple others in the running. But it was always going to be Brett. There was no doubt it was going to be Kavanaugh. That was Kavanaugh and the White House counsel Don McGahn were like two star-crossed lovers in the night. They had to unite, no matter what the Montagues and Capulet said. That was the pick. Okay, so in 2018, Justice Kennedy retires on the last day of the term. He actually goes to the White House to personally deliver this message to President Trump, which is, classic Kennedy. That's exactly what he would do. No advance notice. He just goes right to the White House. Trump didn't even care at that point. He's like, yeah, go away, Kennedy. There's this video of him sort of shooing Kennedy away. It's hilarious because at that point he already got what he wanted. Then we move on to the Kavanaugh confirmation hearing. Well, there were 2, actually. The first confirmation hearing was, predictable. Talked about some issues. Kavanaugh said he was an originalist, which is good. There's some good stuff there. But then we had the Blasey Ford allegations come forward. I thought actually Kavanaugh would drop out or Trump would force him to drop out, but that's not Trump's style. He responds to these accusations forcefully. And Kavanaugh was confirmed by a very narrow vote. Okay, so now we have a seated court with 5 actual conservatives, not like Kennedy's moderation. You have the rock-ribbed Neil Gorsuch and the Brett Kavanaugh, who was born to be a justice since he was 5 years old. He wanted to be in the Supreme Court, exaggerating slightly. His first term on the court was somewhat uneventful. There weren't too many big cases last year. But this year, the October term 2019, proved to be very momentous. This term proved that not all justices who make it through the Federalist Society ringer will vote in lockstep fashion. I, of course, am speaking about Justice Gorsuch and Chief Justice Roberts. In March, of course, the term went on hiatus with the COVID epidemic, and all the justices went home. Eventually, they decided to hold arguments over teleconference. No Zoom. No, that'd be too much fun. But the justices held their arguments over telephone, and they started delivering opinions remotely. Through March and April and May, things were more or less going according to plan as we expected. Then we got the first major COVID case. It was a case called South Bay. It was an appeal from California. And California, like most states, had put restrictions on public gatherings. And houses of worship were subject to restrictions on how many people you could fit in a given indoor space. This case was appealed to the Supreme Court. And the vote split 5-4 against the church. And Chief Justice Roberts wrote the majority opinion. And I don't have time to get into specifics, but he basically said that the state has discretion to treat a church like other comparable gathering places and does not need to justify its treating some gatherings one way and other gatherings another way. That the state has latitude. Justice Kavanaugh dissented, joined by 3 others. That was our first sign something was up. Then we move along the month of June, and we get to a day I call Blue Monday. It was a sad day. In the span of 30 minutes, this court decided significant rulings. First, they denied review in 10 Second Amendment cases. 10. They've been on the docket forever. What had happened? Well, according to the speculation, the Chief Justice was not ready for a gun case. And he signaled that if you take a gun case, he will rule against the Second Amendment. So the conservatives punted. And they just said, we're not going to take it. They had the votes, they didn't take it. We then had the ruling that really shocked people in Bostock. Bostock was a case involving the Civil Rights Act of 1964. The act makes it a prohibition to discriminate against a person because of sex. And I'm not quoting the full statute because it's long, but those are the important words. Discriminate against because of sex. For decades, every court that considered that issue agreed that this statute does not prohibit discrimination on the basis of sexual orientation or gender identity. The lower courts divided on this question. The Supreme Court granted review. The case goes to the Supreme Court, and the vote is 6-3 in favor of the plaintiffs. Justice Gorsuch wrote the majority opinion, and Chief Justice Roberts joined that opinion. And Gorsuch purported to apply what he called textualism. I don't have time to describe it. I think he's wrong, but that's not why I'm here. That's not my talk for today. It's another talk. Have me back later this year. Talk about Bostock. Whether or not Gorsuch was right about textualism, this decision sent a shockwave through the conservative legal movement. Right? Neil Gorsuch was not Anthony Kennedy, the sort of moderate who was put on after the Bork nomination failed. Neil Gorsuch was not John Roberts, this sort of cipher who had never said a word about anything to anyone. Neil Gorsuch had been a card-carrying member of the Federalist Society for decades. And the argument became, how could it be that Gorsuch could reach this conclusion? And I think this case reveals a schism among conservatives. It's very easy to say you're a textualist and you're originalist, but I think we should be candid that a lot of conservatives don't care what ism you follow. They favor results. And I don't begrudge them. Not all of us are lawyers. Not all of us can be fortunate enough to take Professor Geddes' common law class and learn about doctrine. For most people, what matters is results. Whether Roe is right or wrong doesn't matter. What matters is abortion should be banned. That's what people would say. And I think the most articulate proponent of this view is Senator Josh Hawley of Missouri. Now, you may not know Hawley's name, but he was a law professor for several years. His wife was a law professor also. Hawley clerked for Chief Justice Roberts, as did his wife Erin. I presented on panels with them. I've signed amicus briefs with them. These are people who are our friends who now are U.S. senators. That's how things go in life. I'm still here in my office talking to my laptop, and he's in Congress. That's how things go. But Hawley flipped out at Bostock. And he cited the failure of the conservative legal movement. And I want to just read you a quote from his piece. It was a public discourse. And he wrote, "The bargain has never been explicitly articulated, but religious conservatives know what it is. The bargain is that you go along with the party establishment, you support their policies and priorities, or at least keep your mouth shut about it. And in return, the establishment will put some judges on the bench who supposedly will protect your constitutional right to freedom of worship, to freedom of exercise. How has that worked out for us?" You see, when Kavanaugh and Gorsuch were picked, they were not picked because they were social conservatives. They were picked for their views on the administrative state. White House counsel Don McGahn was very clear about this. He cared far more about Chevron deference than he cared about Roe v. Wade. He cared far more about the non-delegation doctrine than he cared about gay rights. The White House counsel has a significant amount of power when picking justices. And this is who Don McGahn wanted. So I think on the administrative state, Kavanaugh and Gorsuch will be lock solid. By these sort of more social issues, I don't know where they fall. I think Kavanaugh is probably closer to the right, but I think Gorsuch might be a little bit woke. I think he just has a streak. Even if you read the opinion from Justice Gorsuch in Bostock, he uses phrases like this person identified as a woman, right? He uses the language that transgender advocates use without any hesitation. If you read the Alito dissent, it does not say that. It doesn't say she, doesn't say he, doesn't use any pronouns. It just refers to the person's last name. I think that's quite deliberate. Kavanaugh also didn't either. He sort of just avoided the issue altogether. You can do that with language. But I think that Gorsuch probably has a liberal streak on certain social issues. So, when he reaches this result, it's not a conservative reaching result he disfavors. I think he reached the result he favors very clearly. Fast forward a couple days later, the court rules in a DACA case that President Trump failed to justify the decision to cancel the deferred action policy. Another shockwave, right? That President Obama created this policy with his pen and phone, was actually the Secretary of Homeland Security. But this was an executive action. And now President Trump failed to rescind it. Fast forward 1 week later, we get to June Medical. This was an abortion case out of Louisiana. 5 justices found that the Supreme Court's leading precedent on abortion was wrong. Whole Woman's Health. 5. Okay? Yet 5 justices upheld the Louisiana law. How could that be, right? How could it be that 5 justices think the controlling precedent's wrong but the law is upheld? Chief Justice Roberts cited stare decisis, which is sort of this nebulous thing that's always lurking in the background. We can argue about stare decisis, have an entire panel on it, but to the average conservative, it's gobbledygook. It doesn't matter. It's, wait a minute, we have 5 Republican justices and we're still losing on abortion. Right? The second major player that I want to talk about in this field, I talk about Hawley, is Professor Adrian Vermeule, who is a professor at Harvard Law School. Yes, they actually have conservatives at Harvard. There's like 2 of them, maybe 3 depending on how you count. Maybe 4 on a given day. Adrian Vermeule wrote a very influential article in The Atlantic. I encourage you to read it, called Common Good Constitutionalism. Vermeule's thesis is, what have conservatives gotten out of originalism? What have conservatives gotten out of textualism? If originalism can lead to Bostock, if textualism can lead to Bostock, then what good is it for us? Instead, Vermeule says we should be inspired by reading the Constitution to promote the common good. And now for Adrian, the common good is defined by the Roman Catholic Church, which he's quite candid about. He doesn't hide that in any way. I suppose we could have an LDS common good constitutionalism. I'll let you guys decide what that would mean. I just beyond my pay grade. But we should have a moral vision guiding us. Vermeule writes, the specific text, the specific contours of the Constitution just aren't very important. What matters are the substantive results that we get. Now, this is like a big deal for me because I've committed my life to saying that's the wrong way of interpreting the Constitution. My colleague Randy Barnett at Georgetown said this is a conservative living constitutionalism. But this idea is gaining currency. In other words, if the left gets away with doing what they want, why can't we do it? Right? If the left says the Constitution is a living, breathing document, why can't we do the same? I'm skeptical this could ever work because liberal judges are more likely to follow living constitutionalism, and conservative judges who were bred in this sort of model of originalism are less likely. But maybe I'm wrong, right? Maybe the next generation of Trump judges will be the mold of Josh Hawley. Indeed, Trump put Josh Hawley on his Supreme Court list yesterday, which was a bizarre pick. He's not going to go for the Supreme Court. But I think Trump's signaling, or at least people, I don't think it's Trump, but people writing these lists are signaling that they're giving credibility to this other school of thought. All right, so where are we now? We are now September 10th. Oh, God, tomorrow's 9/11. I almost forgot. September 10th, 2020. The president just released a list of 20 more nominees to the Supreme Court. We're up to 44 people. There are 44 people on this list for 0 or 1 vacancies. It's ridiculous. I don't know what the point is, right? It doesn't even matter. The list is just, it's who's not on the list. I'm not on the list, but it's basically everyone's on the list. Will this list motivate people to vote for Trump in the election? I have no idea. I have long ago stopped trying to make predictions about politics. I'm always wrong. Maybe Professor Geddix has a better crystal ball than I do. But I have no idea what the hell's going on. It's beyond my pay grade. But we will have an election. And we can maybe sketch 2 possibilities. If President Trump wins re-election, he may get to replace Justice Ruth Bader Ginsburg. The hands-down favorite is Amy Coney Barrett in Indiana. She was a law professor for many years, and now she's a Seventh Circuit judge. I think that's a pick that would very likely happen. Maybe Justice Thomas steps down, although I hope he doesn't. I don't think Trump can pick anyone better than Thomas. I think Thomas is the best, but I'm biased. Look, Justice Breyer's in his 80s. Justice Sotomayor is in her 60s, right? It's not a guarantee that any of these people make it another 4 years. It's always possible. But even if Trump only gets 0 or 1 Supreme Court seats, I think his most enduring legacy will be the lower court judges. He's appointed, I forget the exact number, I think it was 100 circuit judges, if that's the number that I think it's floated around, but 100 circuit judges, which is stunning. I mean, to be fair, Mitch McConnell kept them open when Obama was president. That's why there were so many vacancies. So it's not just, Obama was doing a bad job. Mitch just wouldn't fill them. But he's filled all these vacancies in a very short time. I think since President Carter, Trump has the record. Carter had all these seats created for him, which we're still feeling the effects of today. So if Trump wins, the judiciary will be quite conservative. But I don't know what that means. Does that mean the sort of Scalia, Thomas conservatism? Or are we moving towards the Josh Hawley, Adrian Vermeule method of conservative jurisprudence? I don't know where that goes. It's a very difficult question. And I think you all, law students at a rigorous university, can help decide the fate of this debate. I don't have a side. I mean, I know what side I prefer, but I don't know what side wins. This is not an obvious one for me. Now, what happens if President Biden wins the election? We're looking at a very different world if that happens. First off, I think the fractures in the conservative movement will become more apparent. When you're in power, people have an incentive to sort of stay together and play by the rules. But when you're out of power, you have civil war. You have internecine squabbles, right? I think there'll be a bloodbath. I don't mean people bleed, but it's going to be a metaphorical bloodbath for people who will fight openly about what went wrong. But if the Democrats win the House, the Senate, and the presidency, I think it's a safe bet. The filibuster's gone. We can just assume that's going to happen. I'll take that bet on anyone who says they keep the filibuster. But let's say the filibuster goes. What's one piece of legislation that will be passed? People often talk about court packing. They talk about the Supreme Court. Okay, we'll put that aside for a minute. The real court packing is not going to be the Supreme Court. It's the lower courts. There is a credible argument that the lower courts are understaffed. And I think as an objective, neutral matter, I think we probably could stand to have more circuit judges. The responsible way to add them is phased in. Every 4 years, you add in a certain number of judges. I think that's a responsible way of doing it. But of course, that's not what's going to happen right now. We can't do it responsibly. They'll add 100 new circuit judges tomorrow. And all that we filled by President Biden. So all the gains made by President Trump in the lower courts will be offset, I think, fairly quickly. Then we get to the Supreme Court. Will there be a stomach for Supreme Court packing? Well, that's what John Roberts lives and breathes. He does not want court packing. He does not want it, does not want it, does not want it. Well, I'll tell you what, Johnny boy, you can't stop it. No matter how much you placate critics, they'll find something to object to. And if there's one adverse ruling, we'll get, not court packing, court reform. Isn't that so much more nice court reform? It sounds like you polish the marble, right? You mow the lawn, you put some water in the fountain, and then you add a few seats to the bench, right? It's just like renovation. It's like spring cleaning. I miss this. I haven't done this in months. I miss actually talking to people in front of my computer. I don't hear laughter. I'm assuming there's laughter coming out from your masks, but I'm just assuming. But there's court packing, and they can do this several different ways. They can impose term limits. They can impose rotating seats where circuit judges can go up to the Supreme Court. They can create panels at the Supreme Court where only 4 justices or 3 justices hear a case at one time. Are these measures constitutional? I'd like to say no, but I think you can make a credible case that some of them are valid, that there's no set seat. Of course, they can just add more than 9 seats, make it 11, compensate for the Gorsuch and the Kavanaugh seats that were stolen. I use that word euphemistically, but the seats that were apparently stolen. And at that point, I don't know where that leaves the conservative movement, because then we have a race to the bottom. If you have 11, why not 13? Why not 17? Why not 19? What are all the prime numbers? 23, 20, 29. I'm trying to think of the prime numbers that can't be evenly divided, right? You go the prime numbers. You could have a 75-member Supreme Court, or just have 535 members of the court, just like the United States Congress. It'd be wonderful. I don't know where this future leads. I think there are fractures on the right. I'm sure there are fractures on the left. I don't think Ruth Bader Ginsburg and Sonia Sotomayor and Stephen Breyer and Kagan agree on everything. They can pool together now where they're in the minority, but to use a line in Power, use a line from Hamilton, winning's easy, but governing is a lot harder. It's a place to stop. All right, thank you so much. I love to hear what Professor Gettig says, as well as our student panelists. Thank you.
Thank you. Professor Gettig's ready. We will hear from your side.
Professor Gettig, I think you're muted. After 6 months, you think I'm used to that, but I'm still not. But I'm sitting here listening to Professor Blackman speak and wondering, why am I here? It's a bit like asking a Los Angeles Dodgers fan, which I am, a rabid Dodgers fan, what he thinks of the Houston Astros 5-year, competitive campaign. And, a lot of me just thinks, yeah, all this bad stuff is going to happen to conservatism, and I hope it does. So,
By the way, I'm a Yankees fan, and I am not happy with the Astros, so I think I agree with you there.
Okay, all right. Actually, there's probably a number of things we would agree on, but of course that's not a useful contribution. So let me just make a couple of observations. And of course, Professor Blackman can respond to these as he wishes or not. You all can respond. One thing that occurred to me as he spoke is that originalism for many conservatives always ever was a fig leaf. We can take a legal realist approach to this. One of the clubs that originalists like to beat up people like me with is that it takes a theory to beat a theory, and you don't have one. Well, now it turns out that originalism wasn't really a theory that many conservatives believed in. It was simply a vehicle to get certain results. And, that doesn't distinguish that kind of conservative from the kind of liberals that they criticize. And of course, as Josh said toward the end of his talk, if liberals can be constitutionalists, then we can too, so why don't we just go for it? People like me have been saying for a long time, I haven't said it in print because I don't think it's a great argument. I don't think it takes a theory to beat a theory is a good argument either. If you're sitting in your car and it's up on blocks and you're trying to drive, a very good response to say, oh yeah, where's your car? You know, if originalism works, it works. And if it doesn't work, it doesn't work. And you really don't need a theory to make that critique. Well, anyway, let me move on to the second. Adrian Vermeule and the Catholic syncretists and the common good, the Catholic moral vision. I have to say, this maybe is something that Professor Blackman and I agree on. Whenever natural law theorists, and I have to say especially Roman Catholics, because they're so rigorous about it, start talking about the common good, it fills me with dread. Because the Catholic common good doesn't have a substantial overlap with the Mormon common good. Catholics, conservative Protestants for that reason, they don't accept the Mormon baptism. They don't believe that we worship the right conception of Christ. They're happy to have our political support in culture war issues, but when things go badly, they don't have our backs. An excellent example is Proposition 8. There's a good case to be made that Proposition 8 would not have passed without all of the Latter-day Saint money and Latter-day Saint volunteer labor that was brought to bear in the initiative process in California. And of course, in the aftermath, there was a backlash, and Mormon temples were desecrated and meeting houses. It didn't last long, but it was, I think, startling to many Latter-day Saints. So in January 2017, our meeting houses are being desecrated, and people are protesting outside of our sacrament meetings. And Rick Warren is giving one of the inauguration prayers. Rick Warren was against Proposition 8 too. He didn't lift a finger, rhetorically or otherwise, to come to the defense of Latter-day Saints. Now, I will say that some Roman Catholics did, although in a sense, the most prominent one really had to, because the Archbishop of San Francisco, who was formerly the Bishop of Salt Lake City, had gotten the Mormons into Proposition 8 in the first place, so he issued a press release and condemned the violence and so on and so forth. But I don't think this is a good deal for us, to ally ourselves with Roman Catholics, with evangelical Protestants, who are our political friends, but not our theological friends. I guess the last thing I'll say is to just say something briefly about the vision of the common good that Professor Vermeule has stated. He's written this famous or infamous article in The Atlantic in which he sketched out his vision of common good constitutionalism. And this is what it looks like. He says, I can't get too specific, but I'll give you an idea. And boy, the idea is bad enough. I don't know what the specifics would look like. But here's what he says, and I'm quoting from the article. The court's jurisprudence on free speech, abortion, sexual liberties, and related matters will prove vulnerable under a regime of common good constitutionalism. The claim from the notorious joint opinion in Planned Parenthood versus Casey that each individual may define one's own conception of the existence, of meaning of the universe, and of the mystery of life should not only be rejected but stamped as abominable, beyond the realm of the acceptable forever after. So too should libertarian assumptions central to free speech law and free speech ideology. That government is forbidden to judge the quality and moral worth of public speech. That one man's vulgarity is another's lyric, and so on. That should fall under the acts. Libertarian conceptions of property rights and economic rights will also have to go, insofar as they bar the state from enforcing duties of community and solidarity in the use and distribution of resources. So that's what the common good looks like from the standpoint of one of its most prominent exponents. Now, secular liberalism has plenty of problems, and maybe particularly has plenty of problems for religious conservatives. I'm a religious liberal, so it affects me in a little different way. My guess is it's not actually not a guess, it's a FedSoc in that, right? So most of you are religious conservatives. So things are not great, and secular liberalism has some things to work out. But I think if you want to make it worse for religious conservatives, for religious people everywhere, then go ahead and adopt an ethic. Adopt a point of view in which it's completely acceptable for the government to ban contraception, even for its use by married couples. That's the logic of the Catholic position, although John Finnis and Robert George sort of slide off it by saying, well, there are prudential reasons. But others on the conservative side, like Ryan Anderson, are perpetually lamenting that contraception, even by married couples, is wrong for everybody, not just for Catholics. I would not describe the LDS position on abortion as pro-choice, but it's not pro-life. We allow many exceptions, including for the mother's health, and the mother's mental health is not excluded. Most of the abortion statutes that, at least at this current moment, are unconstitutional. The restrictive abortion statutes enacted in red states, so to speak, would prohibit abortion in many circumstances in which Latter-day Saint teachings suggested it should be available as a prayerful option. We can go through the list, but I guess if this is the future, common good constitutionalism, my advice to Latter-day Saint conservatives, a Dodger fan giving advice to the Astros, I guess, is just say no. Thanks very much.
Thank you so much. And we'll allow Professor Blackman to respond if you'd like, or then we can go into we have a couple questions that arisen in the chat. Quickly, before I let you respond, if you'd like to, Professor Blackman, I again want to thank both of our panels today. One thing that we're passionate about, especially this year, is doing a good job to show civility as we continue to invite people from different perspectives to talk about sensitive and delicate issues. And so I'd like to thank both Professors Geddix and Blackman for showing us how to agree and disagree in a very civil way, and in the process really educate so many of us. And although we are the Federalist Society chapter here, we always encourage all the members of our faculty and of our student body to come join us regardless of their political backgrounds. Thank you both.
Oh, my pleasure. And I've known Professor Geddix's work for many years, and even where we disagree, which is often, I still always respect where he's coming from. And by the way, I'm a Yankees fan, and I attended the ALCS game where Jose Altuve nailed that home run. And I was actually in the bleachers, and I saw the ball go over Aaron Judge's head. I saw that ball. I'm like, no way. So I couldn't hear the banging drum because I was too far from the dugout. But I am convinced I was one of the balls Jose juiced.
Altuve assures us that it didn't help.
No. Can you imagine if we gave our students the questions in advance by banging 2 bangs for A, 2 bangs for B, 3 bangs for C, right? Someone tapping a pencil on their desk during a final exam. Has no one tried that? Oh boy. Anyway, I'm going to stop. I actually want to hear what the questions from the people in the audience are. I've talked enough.
Oh, that sounds good to me too.
Thank you.
Okay. So Christopher Nelling has asked a question. I'm going to check and see if he is available to talk. I'm going to allow him to do so. If not, I can read his question. So Christopher, do you want to ask your question if you're there?
Yes, thank you, James. I often apologize that I got on late and was unable to see the video. I was taking a friend to get a COVID test. Not for me, for somebody else. Anyway, the question is, Professor Blackman, that feeling you described of kind of betrayal that, we nominated these judges and this is the result they have. I'm kind of stepping back, and is that just our fault for having too high of expectations? Is being upset about what judges end up deciding, is that, for the average person, is that our fault for getting too emotionally invested? I just curious to hear your comments on that. Thank you.
Yeah, I don't feel betrayed. Those are the words that Josh Hawley and others use. I understand why Gorsuch did what he did. I think he made an egregious error of constitutional law. I mean, of statutory interpretation. I think he screwed up. But I get why he did it. I don't think he was some sort of turncoat. I would love to explain to a non-legal audience, the canons of statutory interpretation, right? How to read a statute. I can't do that. For people, they say, well, who won, the conservatives or the liberals? And that's what they see. I can flip this around. We've talked about the failings on our side. On the other side, the average rank and file Democratic voter could not give a fig what Obergefell said. The only word that mattered is reversed at the last line, that gay marriage is allowed. That's all that mattered. The content was irrelevant. For supporters of gay rights, they don't care what Gorsuch wrote. It was actually a fairly textualist opinion with some language that I think is not very helpful to the liberals in the future. They'll get away from it, but the results matter to both sides. Liberal judges, they do what they do, but they deliver results. People are happy with results. Conservative judges are not going to deliver with any sort of consistency. Maybe they will in cases, but in 90% of the cases, they'll be fine, but that 10%, it's not going to be consistent.
Great. Is there anything that you'd like to add to that, Professor Geddes, before we move on to the next question? You are muted, by the way.
I obviously disagree with some of Professor Blackman's takes on Obergefell and on Bostock, but that's not why we're here, is specifically to debate those cases. So I think maybe another student question would be better.
Great. Okay, Victor Moxley is next in the queue, so let's see if he's available. I'll give him the ability to ask his question. So 1 second, Victor. Okay, you should be allowed to talk now. If you ask your question for Professor Geddes.
Great. So I was wondering, when we're talking about methods of stacking the court, this was the first that I'd heard of the possibility of filling the circuit court judges. But I'm wondering, besides being a legal possibility, is it a political possibility that they might also create an intermediate court between the circuit courts and the Supreme Court that would be full of more liberal judges?
Okay, so let me see if I can just get your structure. So you'd have the district courts, you'd have the Court of Appeals, and you have the Super Court of Appeals, then you have the Supreme Court. Is that just what you're getting at?
Yeah, my understanding is that the Constitution allows Congress to set up lower appellate courts however they feel is necessary, and I'm wondering if that might be a possibility that we have to be afraid of.
I also teach property, and there's a concept in property called sub-infeudation, which may ring a bell, where in the medieval system you would have these different layers of property ownership, the serfs and the masters and the lords, and they keep inserting different layers into it, so everyone would be subordinate to everyone else. I mean, sure, why not? You could have a dedicated court that sits between the appellate court and the Supreme Court, right? What might that look like? Maybe it only hears certain constitutional claims, right? I actually think a huge benefit would be to go back to the three-judge panel approach. Throughout much of the 20th century, if you had a constitutional challenge, it was brought before a three-judge panel, 2 district judges and a circuit judge. And they issue the decision quickly. I think it's insane that these constitutional rulings take 2 years to decide. It's to no one's advantage. And to have 20 district courts issuing competing nationwide injunctions, I would just cut to the chase and just have a single dedicated 3-judge panel and go right with appellate review to the Supreme Court. That's how it works in the campaign finance context, right? There's a dedicated right of review. So I'm not opposed to streamlining constitutional law, but this is just a pretext to add 100 new Democratic appointed judges. Like, all right, whatever. We know what we're getting. I think any addition of judges should be phased in over every 4-year period. It cannot be done all at once. I mean, it will be. I shouldn't say it cannot. It will be done all at once. But I think it's just going to be a naked effort to put more people on the court.
Professor Geddes, any response there? And I also want to tack on one of my own to add to the question. I'd love to hear your thoughts on if the Ninth Circuit should be split into two circuits on top of that. If that's politically feasible or what?
Just quickly, I don't disagree with anything that Josh has said on that issue. I do think politically that if the Republicans take back the Senate, which is a possibility, and Biden is elected president, I think that the left wing of the party and perhaps many establishment Democrats will demand an expansion of the Supreme Court to 11 to counteract the stolen seat of Merrick Garland. I don't think most Democrats view Kavanaugh's appointment as a stolen seat. They just view it as, well, whatever. And I do think that politically Democrats want to control the judiciary within its current structure. I think it's far more likely that they would expand the circuits, the circuit court judges by 100 and to add an intermediate level, because that's just sort of a crapshoot. You don't know who's going to win with that. As far as the Ninth Circuit is concerned, I clerked on the Ninth Circuit. This issue has been around for, before I clerked, so more than 40 years. And the real problem is no state in the Ninth Circuit wants to be paired with California. California is the giant gorilla that would overwhelm the law of the circuit, and thus the circuit law for any state that attached to it. For a long time, there was some momentum for attaching Arizona, and Arizona was sort of inclined to do that because once upon a time, California law was looked at in the Arizona state courts as particularly persuasive. But Arizona has the second highest number of filings in the Ninth Circuit after California. So splitting those two off doesn't really solve the problem. Anyway, I suspect it'll never happen.
Justice Kennedy, I had the privilege to clerk for Judge Howard Nielsen after law school. And Justice Kennedy came in and performed the investiture ceremony. And he has an interesting idea on this, where he's thought about actually splitting California into three separate areas and turning the Ninth Circuit into three circuits. So you have a northern, central, and southern. It would be southern with Arizona. It would be central with many of the Midwestern states, and then northern would be aligned.
That would make form shopping a nightmare, because if you have a venue in California, you choose a circuit you want to be in. Wow. I would just make a California circuit. Just make it its own circuit and just let it deal with itself.
Great. Well, thank you both so much. Again, this has been a really fascinating event, and I appreciate both of your perspectives. In light of the tradition that we normally have to allow people a couple minutes before their class, we're going to dismiss everyone. But even though you might not hear it, this is a moment where I'll give you a virtual applause, even though the rest of the attendees are muted. If anyone would like to stick around for a couple minutes after, we can have an informal discussion. I know that Professor Blackman
be happy to stay.
has agreed to stick around for a couple minutes. Professor Geddes, please, if you have some time. If not, no worries. You can prepare your great 14th Amendment lectures, and I always appreciate that. So thank you both.